Yeah, just so you know. It's actually live. I don't think audio is live. I do like this music, it's relaxing. Okay, it's 3 o'clock. Why don't we get started? Thank you all for coming to the public square on the Indian Child Welfare Act. We are delighted to have an extraordinary panel and wonderful moderator here today. We will have some instructions at the end, so don't panic for those of you looking to get your service credit for attending this event toward the end. But I would first like to introduce our panelists. First, we have Kyra Antone. Kyra's Indian name is Keohot, which translates to rainbow. She is Coeur d'Alene and Thanatham and a direct descendant of Chief Spokane Gary. Kyra is a graduate from Washington State University, where she majored in digital technology and culture while minoring in both fine arts and comparative ethnic studies. She won all the awards, I think, while she was here, including the President's Leadership Award, the DTC Community Service and Engagement Award, and the DTC Outstanding Senior Award. She was also in the Tribal Nation Building Leadership Program led by the Office of Native American Programs. Kyra is very passionate about working with Native communities and believes that storytelling can be a form of both learning and healing, and how true that is. Before joining NICWA, she taught Native youth how to create podcasts with Voices to Hear, was a communications consultant for the Center for Native American Youth at the Aspen Institute, and spent time as a production assistant working on telling the stories of Indigenous people with Providence Pictures on the PBS series Native America 2.0. Yes, you all are lucky to be here today. We also have Dr. Sarah Kastilic with us. She is an enrolled citizen of the Native village of Uzinki, and she became the executive director of the National Indian Child Welfare Association in January 2015. Prior to joining NICWA as chief of staff in 2011, Sarah led the National Congress of American Indians Welfare Reform Program, and in 2003 was the founding director of NCAI's Policy Research Center. She began her career at the Bureau of Indian Affairs Central Office as a child welfare specialist in 1998 and earned her master's degree and PhD from the Brown School of Social Work at Washington University in St. Louis, where she serves as adjunct faculty. The students there are amazing. We just attended a conference with some of them, unbelievably civically engaged, which I know that Washington prides itself on. Sarah has served as principal investigator of several national, federally, and privately funded research projects, partnering with tribally based and urban Indian communities. She's authored numerous publications, including journal articles, book chapters, and curricula. She's a member of the boards of directors of Independent Sector, Generations United, Native Ways Federation, and Underscore. So thank you all for coming. We now have Zoe Hyeagle-Strong as our moderator, and we will have a little time for you all to ask questions in a Q&A toward the end. Zoe.
Tatalap, good afternoon. My name is Zoe Hyeagle-Strong. I serve as Vice Provost and Tribal Liaison to the President here at Washington State University, and also faculty in Educational Psychology. My Indian name is Huku, and I'm a citizen of the Nez Perce tribe. I want to take a moment just to acknowledge the lands that we're on, which is a part of the Nez Perce Nimipu tribe and the Band of the Palouse peoples. And why that's important, we often hear about land acknowledgements, which can be controversial. Sometimes they drive me crazy, and sometimes I really appreciate them. But why we do that is because, we have a historical past as a land-grant institution that ties back to Indigenous lands. Through the Enabling Act and also through the Morrill Act of 1862. There was a lot of broken treaties and coercive means of why the Indigenous lands were taken. And that was given in these acts to start our land-grant institution. And so we really owe an obligation. Just recently, we looked at the data, and just the last 24 years, there's been $543 or $543 million that we've earned from Indigenous lands that we currently still retain. So actually, Washington State University across the U.S. has profited more than any other land-grant institution. We're one of the top. So that's why we take those moments to think about, paying debt or obligation to those who have gone before us, but are active in our communities still. And so I'm excited today to take a minute to talk about the recent Supreme Court ruling, and for us to get to know a topic that maybe many of us are not familiar. And I really appreciate you as students, as you're engaging and learning many different topics and policies and decisions and learning it from a community perspective. So thank you for Katsiaoya for being here with us today. And I'm going to start us off with some questions, and I'll go back and forth a little bit. And we'll probably have a little bit at the end for you guys to think about a question, or perhaps I've asked all the questions. So we'll start off. But for those of you who have little knowledge of the National Indian Child Welfare Act, which is called NICWA, or the Federal Indian Child Welfare Law, which is called ICWA, you'll see those two acronyms. I'm going to start off with a couple questions that can help provide some additional context. So Sarah, I'll start with you. What is ICWA, and to whom do the protections of ICWA apply?
Thank you, Zoe. So first of all, I just want to say, Chamai, everyone, good evening. Thank you all for being here with us. So honored to be here with all of you, and Koyana for your time, for your hospitality. So the Indian Child Welfare Act is a 45-year-old federal law. It's a restorative law, meaning that Congress passed this law to redress past harm. So it's a corrective law. And the Indian Child Welfare Act does three things. So first, because of the history of the forced removal of Native children from their families, first through boarding schools and then later on through the public child welfare system, the Indian Child Welfare Act puts in place minimum standards for state agencies to remove Indian children. So in order for a state to be able to remove Indian children, they have to meet certain kinds of criteria. And that was very intentional on Congress's part. That was a way to put up some guideposts to guide state behavior and to end that egregious practice of removing Native kids from their families. So that was the first thing that ICWA does. The second thing it does is that it acknowledges tribal nations as sovereign governments, and it recognizes that governments have an interest in their citizens, especially their most vulnerable citizens, in this case, Native children. And then the third thing, the final thing that ICWA does is that it provided some pretty meager federal funding to tribes for the first time to start programs to serve Native kids and families, to serve their citizens. So those are kind of the basics of what ICWA does. And ICWA actually applies to a pretty narrow subset of the US population. So the Indian Child Welfare Act only applies to children under the age of 18 who are a member of a federally recognized tribe or who are eligible for membership in a tribe. So that means if you're a self-identified Indian person, but you're not a member of a tribe, ICWA doesn't apply to you. If you're a member of a state-recognized tribe, or if you have family blood from many different tribes but are not eligible for membership in a tribe, ICWA does not apply to you. So it actually only applies to a pretty narrow swath of Native people, just people who are enrolled citizens of a federally recognized tribe.
Excellent. Thank you, Sarah, for that context. The next question applies to you both, but I'll ask Kyra to answer first. What is tribal sovereignty, in your opinion, and why is it relevant to ICWA?
Tribal sovereignty is the ability for Native tribes to govern themselves. So we have like our own tribal councils, our own tribal government entities, and it's one thing that I have always been told growing up is that we were never given sovereignty. It's something that we've always had. And for example, there are 574 federally recognized tribal nations within the U.S. all of which have had tribal governments that predate federal and state governments. So I feel like in the most basic terms, that's what tribal sovereignty is.
Thank you.
So I concur. I agree wholeheartedly with Kyra. And I guess what I would add is that tribal sovereignty and tribal nationhood mean that the relationship between a tribe and their members is a political relationship. It's a relationship of citizenship. Tribal members are citizens of tribal nations. And that's really important because in the court case that we're going to talk about very soon, the opponents in the case claim that ICWA is a race-based law, that it's unconstitutional because it's a race-based law. And so understanding that ICWA only applies to children who are citizens of tribal nations, of federally recognized tribes, is really important because it completely undercuts that argument because ICWA has nothing to do with race. It doesn't take into account race of children or families. It's only concerned with citizenship, with political relationship. And that's why tribal sovereignty is so important. It means that tribal nations have an interest in their citizens, in their future citizenry, so in the children who will be their future leaders. And that's why tribal sovereignty is so important in the context of the Indian Child Welfare Act.
Yeah, and tribal sovereignty is one of the, I think, terms that are often confused. And if we look at it from a WSU perspective, why we have an Office of Tribal Relations is because when we think about tribes as sovereign nations, that there's supposed to be a government-to-government relationship at the highest level. And, there's federal and state legislation that requires tribal engagement and consultation before making an impact or a decision that impacts or has a foreseeable impact on tribes or their federally recognized tribal members. And so that's why we have an Office of Tribal Relations. Here at WSU, we actually have an MOU agreement with our regional tribes that is between the president, the provost, myself, our regional tribes, and so that we gather a commitment of relationship and engagement twice a year. We get together and talk about critical issues and make decisions, and we run things by before moving things forward. And so, and just a bit more context that here in Washington State, there's 29 federally recognized tribes. And then we also honor the tribal homelands of our bordering tribes because their traditional lands and their ceded areas were in Washington State. So like the Nez Perce, Coeur d'Alene, Salish Kootenai, Umatilla, Warm Springs, those are tribes in Oregon, Montana, and Idaho, but their traditional lands are here, their fishing rights and other things. So we have to also have MOU agreement with them and honor their traditional lands here. So the next set of questions pertains to the recent Supreme Court challenge. Sarah, in the recent Holland versus Brackeen case before the Supreme Court, who was fighting for ICWA, who was opposing it and why?
Yeah, so this is the heart of the conversation here. So this case started in 2017. And at that time, the Attorney General of Texas, Ken Paxton, sued the federal government, sued the U.S. Department of Interior, and alleged that the Indian Child Welfare Act was unconstitutional, that it violated the U.S. Constitution. And so at that time, when this case started in the federal district court in the Northern District of Texas, the case was actually called Texas v. Zinke. So the state state of Texas was suing the U.S. Department of the Interior, and at the time, Zinke was the Secretary of the Department of the Interior. This case was really about the state of Texas and a handful of non-Native foster parents who are fostering Native children that they wanted to adopt. They were suing the federal government, claiming that ICWA was unconstitutional on a variety of grounds that we'll talk about soon. But basically, standing up for ICWA, defending ICWA, was the federal government. So the U.S. Department of Justice represents other federal agencies when they get sued. So the Department of Justice was representing the U.S. Department of the Interior. And then 4 federally recognized tribes petitioned the court to intervene in the case, to become parties in the case. So the Cherokee Nation, the Oneida Nation of Wisconsin, Quinault Indian Nation here in Washington State, and Morongo Band of Mission Indians were the 4 tribes that became parties to the case. So who was against ICWA and who was for ICWA and why? So the state of Texas claiming that ICWA was unconstitutional. It's really clear that the Attorney General had a political agenda here. Actually, the state of Texas was getting along pretty well with tribes. The State Child Welfare Agency had working agreements with tribes, and in child welfare proceedings, they had protocols for how to work together. But the Attorney General has a states' rights agenda and was concerned about tribal sovereignty and about tribal sovereign authority over tribal lands, over tribal citizens, over natural resources. And so the Attorney General had more of a political axe to grind. He was more interested in advancing states' rights and really undercutting tribal rights. So that was the interest there. And we can talk more about how we know that political agenda was there and how that's played out in other ways since then. But that was the issue for the state of Texas. And then the handful of non-Native foster parents wanted to adopt Native children. And the Indian Child Welfare Act has provisions that say when Native children have to be removed from their families, when it's not safe for them to stay at home with their parents, there is a hierarchy of placement preferences where they should be placed. So if a Native child is removed from their family, the first place that they should be placed is with their extended family. So of course, we know that kids will do better with their family, that they'll have more continuity, they'll be able to maintain many of the familial relationships, maybe even stay in the same school. So when kids have to be removed, they are placed with their family first and foremost. And so the non-Indian foster parents took issue with this. They wanted to adopt those Native children. And so they had an issue about the constitutionality of ICWA. Those were the claims that they were making. On the other side, the U.S. government defending ICWA and the tribes intervening to defend ICWA were all arguing that the claims that the opponents were making were baseless claims. And spoiler alert, as we'll talk about in more detail, the court also found that to be true. So there were some political agendas and some personal agendas around custody of Native kids on the part of folks who are filing this case, making these claims against ICWA, and then on the side defending ICWA, really alleging that those claims were baseless, which the court ultimately found to be true.
Thank you. For the Protect ICWA campaign, how did that play a role? And this question is for both of you.
Oh, yeah. The Protect ICWA campaign is made up of 4 Native-led organizations, including the National Indian Child Welfare Association, the Association on American Indian Affairs, the National Congress of American Indians, and the Native American Rights Fund. And together we work to serve and support Native children and families. So creating the Protect ICWA, it's basically policy, legal, and communication strategies to help inform people on the topic.
Thank you, Karen.
Yeah, so I really like to think about this national partnership that Kyra is describing as a three-legged stool. So if we're trying to defend the Indian Child Welfare Act, if we're trying to make sure that these protections for Indian kids and families remain in place, there are several ways that we need to do that. As Kyra said, first through litigation. So this has not been the only case that was filed regarding the Indian Child Welfare Act. In fact, in the last 10 years, we've seen a wave of anti-ICWA litigation, including parties such as the Goldwater Institute, which is a conservative think tank in Arizona that was involved in more than a dozen cases making claims about the Indian Child Welfare Act. So we know that mobilizing around litigation and being involved in litigation is a really important way to defend ICWA against the attacks that it's facing. Policy is the second way. So whether it's policy at the federal level or at the state level, or even at the tribal level, there are lots of ways to use policy to make sure that ICWA is being implemented properly and to ensure that states are complying with the law. So there are a whole lot of different strategies in that second leg of the stool. And then the third leg of the stool is really Kyra's area of expertise. But when we turn our attention to the communication strategies, one of the things that we know is that the court of public opinion matters. So it's not just the courtroom and the justices in the courtroom, but actually the court of public opinion influences the justices in the court. And so it was very important to have a communication strategy that was communicating to the general public and to particular groups of organizations and people who may be like-minded, may be allies of ours, about what ICWA is and about why it's still needed today. So there was really, for the first time in our organization's 40-year history, a real effort to prioritize communications and to invest even in external communications partner who helped us to strategically educate the public, mobilize people on social media, and even develop a series of calls to action that Kyra may tell us more about in a few minutes.
Excellent. Thank you. And can you, Sarah, talk a little bit more, just providing an overview of the actual ruling, recent ruling, and how that impacts Indian country?
Absolutely. So the Supreme Court's decision in this case, Holland v. Brackeen, was handed down on June 15th. And this decision was stunning. This was a completely unexpected decision. There was a great deal of concern and uncertainty about what this court would do. It's not a court that has a lot of experience on Indian country issues, and several of the justices were untested on these issues. And so as time wore on, as we waited longer and longer for the court to hand down a decision, there was really a lot of anxiety in Indian country. And so when the decision came down, it was a resounding 7-2 decision. So 7 justices were on the majority opinion, basically saying ICWA is constitutional. We don't buy any of these claims about why it's unconstitutional. So the majority, 7 justices, found ICWA constitutional. And the opinion, the ruling, was authored by Justice Amy Coney Barrett, who's one of the newer Supreme Court justices. But importantly, in this context, is also an adoptive mom. So she was a justice that we weren't sure how she was going to come out on these issues. But not only did she find in favor of ICWA, but she actually authored the majority opinion. So that's really significant. So this was a resounding victory for Indian country. And the Supreme Court really refuted all of the opponents' claims. And so let me talk about those for just a minute. First, the opponents claimed that Congress never had the authority to pass ICWA in the first place, that Congress exceeded their plenary power, as the Constitution calls it. And the majority and and Justice Barrett, writing from the majority, said that's baloney. Congress definitely has this authority. Congress has broad authority. She even called it muscular authority to legislate on behalf of individual Indians and on behalf of Indian tribes. So Congress definitely has the authority to legislate for the benefit of Indians. So that was the first claim, and that was the majority's response. The second claim was about something that's called commandeering. And so the idea here, the opponents were claiming that the federal government was butting into something it didn't have the authority to regulate. So by and large, states have a lot of authority to regulate the area of child welfare. And the opponents here were saying that that the federal government was commandeering states, that they were interfering in states' ability to regulate child welfare in their jurisdictions. And so once again here, the majority said, nope, we don't buy that argument either. And what they actually said here was the federal government definitely has a role in child welfare. And they have a role not only as a funder of services, the majority of funds that states use to develop child welfare programs and to fund services, most of those funds are federal funds. So the federal government has a role in funding child welfare, but they also, importantly, have a role in setting standards in child welfare. So again, the majority refuted the opponents' claims there. And then the final claim that the opponents made, the most dangerous claim of all, is the claim that we mentioned earlier, the claim that ICWA is actually race-based, that it violates the Equal Protection Amendment of the Constitution. And on this issue, well, first of all, as we already talked about, ICWA only applies to children who are members of a federally recognized tribe or eligible for membership in a federally recognized tribe, which means this is about political status, it's about citizenship, it has nothing to do with race. And actually on this issue, the court didn't actually rule. The court actually found that the parties that brought the case, the state of Texas, the handful of non-native foster parents, that they didn't have what's called standing to bring this claim forward. So what standing means is that basically these parties weren't injured by the law, by the Indian Child Welfare Act. And even if they had been, the Supreme Court wouldn't have any way to provide a remedy. They wouldn't have a way to fix the problem. They wouldn't be able to provide relief for the parties that brought the issue. So what they said is these parties don't have standing to bring this because there's no way this court could do anything to rectify it. So basically, they kicked that issue, the most dangerous issue, on standing. So they didn't rule on it, is what it means. So that is an issue that could potentially be brought forward at a different time in the future if the opponents can find a way, can find the appropriate parties, can figure out the model case to bring something like this back to the court. And already the opponents have said, we're working on it. We'll bring you another case. We'll bring this right back to you. So it will take some time for them to find an appropriate case and to bring it back. But we do know that this is something that's kind of looming in the background now, even though the other issues in this case were a resounding victory for Indian country. We know that there's this other issue hanging out there that at some point may come back to the court again.
Thank you. Well, that perfectly leads to my next question is, with the Supreme Court's affirmation of the constitutionality of ICWA, what's the next for ICWA's advocates and how can people help? So those here in the room that may be interested, students, how can we help? And if you want me to repeat the question, I'm happy to do so as well.
Oh, yeah. So as Sarah said, basically, despite the ruling, challenges still remain for ICWA. And so if you would like to help, please follow the Protect ICWA campaign on Twitter and Instagram. We are focused on educational on an educational campaign, and our core message is basically don't fall asleep at the wheel, because we got over one hurdle, but there's still a road ahead in protecting ICWA. So please follow us on Instagram. And we have a shameless plug. We also have a link tree that has articles, podcasts. If you haven't listened to This Land podcast, it's on Apple, Spotify. It's a really good podcast and dives into all the stuff going on. So
Can you say the name of the Spotify again?
This Land.
This Land. Okay. Thank you.
So, so we know that at some point the opponents may bring this issue back to the court. So we have to be monitoring litigation in an ongoing way. So we're looking at cases that are appearing in states. We're looking at federal district court cases where ICWA is being challenged. We're talking with tribes about paying attention to the constellation of folks who are working on these cases. Who are the attorneys that are representing them? Are these people who are showing up in your tribal court that you've never seen in your community before? So really trying to understand the series of test cases that the opponents are going to try to bring in order to put together a case to try to bring all the way back to the Supreme Court. So we have to be vigilant about monitoring the litigation, paying attention to what's going on, because at some point something could come back. That said, let's not forget this incredible victory that nobody was expecting, where 7 justices of the Supreme Court said tribal sovereignty is the law of the land. This federal government has an obligation to tribes. Tribes have every right to be involved in determining what's in the best interest of their own citizens and being involved in cases that involve their own children. So that's an incredible foundation to be standing on at this moment. We thought that we might be in a position of having a really bad decision and trying to regain some of that ground, claw back some of those protections, but that's not the situation that we're in. The court has really affirmed the legal foundation of ICWA. And so we say this is a time to be emboldened in our advocacy. This is a time to press the gas pedal all the way to the floor. There's lots of good work that we can do around strengthening implementation of this important federal law. There are lots of things that we can do to ensure that states are actually complying with the protections that are in place. So there is a broad advocacy agenda, and it's playing out at all levels of government. So the first place to start is right in our own communities. When we look at tribal communities, tribes can use some help to build more capacity to have stronger child welfare programs in their community, because the stronger the tribal programs are, the more kids we can keep out of the state system. So if we can serve Native kids, Native families in our own tribal systems that are often less punitive than state systems, that are often more oriented towards wrapping services and supports around families, less punitive, offer an opportunity for healing. Those are things that are going to work better for Native kids and families. So how can we keep more Native kids in our tribal systems and out of the state system? So that's one area of work at the tribal level. There's also work to do at the state government level, and in particular, work that tribes can do in partnering better with states. So ICWA is a law that governs state behavior. ICWA doesn't actually ask tribes to do anything. It provides a little bit of resources for tribes to develop some programs, but ICWA doesn't govern tribal behavior. It governs state behavior. And so, so states are the ones that have the requirements of protecting kids that are involved in state custody cases. But we know that states can't do this by themselves. They need tribes as partners in order to be able to implement the protections of ICWA. So there's a lot of work to do at the state government level to develop better relationships between states and tribes. States and tribes need to be able to work better together to implement the protections of ICWA, which means that more kids can stay safely at home, or if they have to be removed from their families, can stay connected to their families, their extended families, their community, their culture. So there's some really important work to do at the state level around that. And then finally, at the federal level, I was just describing how in this Supreme Court decision, the justices said the federal government has a role in setting standards for the well-being of kids. So there's a lot of work to do at the federal government level. I keep telling people we should be taking this ruling to the bank. We should be telling the federal government, we need you to step up. We need you to do more to set standards for the well-being of Native kids. And that means things like actually collect some data about how tribal kids are doing in state child welfare systems. So we need data. We need a regular review. We need to be looking at how is this law being implemented? How is it serving families and kids? What kind of outcomes are families and kids having when they go through this system? It's almost unconscionable, actually, but ICWA is the only federal child welfare law that doesn't have a review. Every other federal child welfare law, Congress reviews periodically, usually every 5 years. They gather data, they're assessing how is this law operating, how are these programs working, and yet ICWA has been around for 45 years. They're not even collecting data about it. There's no kind of regular review in place. So that definitely needs to be remedied. So there are a lot of things that can happen at the federal level too, that can strengthen these protections, that can ensure that ICWA is actually being followed, and that Native kids and families have better outcomes because of these protections.
Thank you. Excellent answer and response. I think it's important to note, too, that data is very problematic, especially federally collected or state collected data. And as we know that, or maybe most of you know, even in institutions like WSU, we go under IPEDS categories, which is where we're counted in either as if you're mixed and you do, even if you're tribally enrolled and you also mix, enter Black or Hispanic, then you're either counted as Hispanic or multi-race. And so there's a lot of data out there that is actually not collecting federally enrolled. So it looks like our population numbers are very small. So like WSU is an example. We have, if you look at the IPEDS categories, we have about 200 Native students. If you look at the all students actually that are the data, then when we go behind the scenes is around 800 and so. And so that's problematic, and the protection of data and who has access and how it's collected is also a data sovereignty issue for another time. And Cheryl Ellenwood will, for sure, Dr. Ellenwood will present that again soon. So I'm going to take a moment and pause and see what time it is. Okay, we're doing good on time. But I want to open it up. I have a few last questions, but they're more personal for Kyra as a WSU alumnus in her work and her transition from WSU. But I do want to open it up to the group. And anyone have any questions on, and there's no silly questions. These are really complex topics, even for me sometimes to wrap my head around. And so please don't hesitate on asking any question. Mm-hmm.
Sorry, I can't see who has the question.
So my question is, have y'all thought about reaching out to non-Native organizations or anyone a part of legislation making, whether that be centered in Oregon or Washington or just like in DC? And if you have, how was the response?
Yeah. Awesome question, right? So the Native population is about 2% of the population of the whole United States. And so when we have a major issue that requires advocacy, it is essential for us to build coalitions in the way that you're talking about. So I think one of the really important things that the Protect ICWA campaign did was to look for potential allies who might share some of our concerns about the well-being of kids, about discrimination in the child welfare system, about best practices for keeping kids safe, and to enlist the support of some of those organizations. So one of the things that happens in a court process is that there is an opportunity for outside organizations and people who don't have a role in the case to actually file briefs with the court to try to educate the court about issues that they think the court needs more education about. And so this is one way to like take the temperature of support for a case, like how many people are on one side, how many people are on the other side. So in this case, as it was accepted, cert was granted by the Supreme Court. The court agreed to hear the case. There was an opportunity for folks on the pro-ICWA side and folks on the anti-ICWA side to file briefs. And so what we saw is on the anti-ICWA side, Texas, the handful of non-native foster parents, and then about, I think, 3 briefs that were filed by a couple of organizations who were saying, we agree that ICWA is unconstitutional, ICWA discriminates against Native kids, ICWA is based on race. So about 3 briefs. On the pro-ICWA side, there were 21 briefs filed, and the briefs were filed by some pretty heavy hitters. So we had 23 states plus the District of Columbia that signed on to a brief that said, we believe in ICWA. ICWA is constitutional. There were 77 members of Congress that signed on to a brief. There were over 500 tribes and 60 Native organizations that signed on to a brief. The American Medical Association, the American Academy of Pediatrics, the American Bar Association all signed on to briefs saying we support ICWA. Importantly, 30 national child advocacy organizations, child welfare experts, signed on to a brief saying, we believe ICWA is the gold standard of child welfare practice. ICWA is the best policy and practice, not only for Native kids, but for all kids. If we could have protections like this that allowed kids to stay with their families whenever it was possible for them to safely do that, that would be best for all kids. So when you look at how these briefs stacked up, it's really kind of funny to see all of the work that we did, all of the outreach, all of the mobilization, inviting people to learn about this issue, to sign on in support of it. And then 21 briefs with hundreds of signatories on it. There were former foster youth saying ICWA is really important. There were birth families, there were foster families. I mean, the list of briefs goes on. So just overwhelming support for ICWA and pretty paltry support on the anti-ICWA side. So that was a really important strategy in this case. Thanks for that good question.
Thank you.
So earlier you talked about data, and specifically what kind of data do you think would be more beneficial to supporting or not supporting ICWA in terms of like quantitative data, qualitative data? Like what would you look for, I guess, and who? Would it be tribes? Would it be federal collecting that data? Just because, data sovereignty is something tribes try to protect as well.
Absolutely. Yeah, thank you. Good questions. So all of the data that's collected in our country about foster care and adoption is collected by state governments. So children are coming through state systems, and the state governments are required to collect this data. It's put into a system, a federal system that's called AFCARS, Adoption and Foster Care Analysis Reporting System. So it's a federal system that the states have to contribute the data to. And states have to contribute the data because they take federal money. So if the federal government is funding them, in exchange for these dollars, states have to report back about the status of kids and their families in the system. So the AFCARS system requires states to collect data. There is some data about race. So it will identify children and their families of different races, including American Indian, Alaska Native as an option to check as a racial category. What AFCARS does not do is ask questions about whether or not the child is a citizen of a tribal government. So we don't know if the protections of ICWA apply to all of the cases that are classified racially as American Indian, Alaska Native. So if we require states to collect data about each case to say, does ICWA apply in this case, check the box if it does, then it means we can also look at whether all of the requirements of ICWA, all of the protections for kids and their families are occurring in the cases that are ICWA cases, because right now there's no way to tell that. So this has been an ongoing issue. We've been advocating for this data to be collected for over 30 years now. At the end of the Obama administration, HHS, the U.S. Department of Health and Human Services, did make some changes to regulations that would require states to collect this. And when the next presidential administration came in, they rolled it back. And so we've been working with the Biden administration to try to get this implemented into final rule to require states to collect this data. And it looks like it's something that will happen. But it has certainly been a 30+ year fight to just try to get some basic data collected from the states about the extent to which they're serving kids for whom ICWA protections apply, in order for us to even be able to tell how ICWA eligible kids are being served by state systems.
Excellent. And we'll take one more question. Over here.
You mentioned you could talk about how you knew the agenda of Texas in the court case regarding ICWA. Can you elaborate on that?
I'm sorry, can you repeat the question one more time?
You mentioned you could talk about how you knew the agenda of Texas in the
thank you.
court case. Can you elaborate on that?
Behind the
Please,
scenes
yes,
question.
love
I
that
like
question. Okay, so part of this relates to the additional cases that have been filed and what the agenda is showing up like. So in January of last year, the same group of attorneys who were representing the non-native foster parents and some of the other amicus brief parties in this case filed a similar case actually in Washington state. And they were suing the federal government, basically saying that the Indian Gaming Regulatory Act was unconstitutional, and they were citing all of the same reasons as the ICWA claims. So basically, this is like starting to go after additional federal Indian laws, including in this case, laws that are about the ability of tribes to do gaming, to have regulated gaming. And they're using all of the same claims. So all of the same people are involved. They're attacking tribal sovereignty. For the first case, they're putting the faces of kids and families on it as a way to engender sympathy. We're concerned about these kids and families. Actually, not so much, because they're going after land rights, they're going after gaming, they're going after natural resources protections. So their larger agenda is really about tribal sovereignty and tribal rights, and the desire to expand states' rights at the risk of really undermining tribal rights. So that's the larger political agenda. Thanks.
Great question. Any one last question before I turn it over to a bit more personal questions for Kyra?
So I was just kind of wondering, as a general question, how does the United States, so like you have tribal sovereign nations and you have the United States, which is a country. Why is the United States getting involved legally if they're like sovereign nations? Does that make sense? Do you need me to
I think so.
elaborate?
Let me start, and then you can correct me if I veer off track. Is that all right?
Yeah.
Okay. So in this case, it was a federal law, a U.S. law. The Indian Child Welfare Act is a federal law. So when the parties were bringing the case, when they were asserting that ICWA was unconstitutional, they were suing the federal government because the federal government was responsible for making the law, Congress's job, and then implementing the law. Which happens, the U.S. Department of the Interior, the Bureau of Indian Affairs, has some oversight over this law. So the federal government was involved because they were being sued because they wrote the law and they're implementing the law.
Okay. I think that makes sense. It makes sense. But yeah.
Thank
I
you.
guess I was just kind of wondering, I'm spacing a little bit.
Is part of your question the confusion of how does the federal government work with tribal nations?
Yeah. So like, is it more of like a partnership? Like, is there oversight? Is it like
Awesome.
working
Yeah.
together? Because yeah, that's
Yeah, that's a good question.
Really great questions. Yeah. The federal government has a government to government relationship with tribes. The origin of this is as Europeans started to come to this country, Native people were much more abundant than the few people who are coming across in boats starting to settle here. So the balance of power was that Natives had much more power than folks that were just coming over and starting to establish colonies and then states. And so there was always historically a negotiated relationship between the tribes that were here since time immemorial and the newcomers to this land. And so I'm not a lawyer, I'm a social worker, but the foundation for policy in this country between the federal government and tribal governments has always been a direct government to government relationship. And that's important because that means that the role that states play in addressing the needs or concerns of tribal nations is a lesser role. So there are a lot of artifacts of history that have to do with how federal laws apply differently in different regions of the country, which affects some of this somewhat. But generally speaking, the direct relationship with the federal government and tribal nations is really important. And it's something that's honored to this day. Numerous presidential administrations, including the Biden administration, continue to hold an annual summit with tribal leaders from across the country as a representation of this government to government relationship.
And here in the state of Washington, it's called the Centennial Accord. So our tribal nations gather once a year with Governor Inslee, and I chair the Higher Education Committee. So different issues across the state, tribal leaders will bring forth to the government, and there'll be negotiations. And so that's what it's meant to be, is that voice. And the challenge is that there is a lot of treaties and a lot of negotiations. When you hear the tension that goes on, is that there's been unfulfilled treaties and promises. And when you hear the rights for Native education, those were promises when land was given, that there was an exchange. And so there wasn't a follow through with a lot of those treaties. So that's where sometimes you see more of the tensions arise. And I do want to invite you on November 6th. I'm putting a little plug in. I will be doing a presentation looking at our history of land grant institutions and the reparation and equity moving forward when we think about Indigenous land. So that's November 6th. It's a common reading, and that will be at 3:30 or 3 to 4:30, and it will be virtual or in person. So I just want to close out with a couple of questions, Kyra. You've been an amazing leader while you're here on campus. You were in the Tribal Nation Building Program, won many awards. But in your time at WSU, coming out from WSU into this work, how did your time at WSU prepare you for your position as a national advocate?
I would say that I owe a lot to Native programs here. I had a lot of support. As you said, I was part of the Tribal Nations Leadership Building courses, where we talked a lot about advocacy, leadership, and on top of that, being a part of different organizations such as Koyama and the Native American Women's Association, which one year we went over to City Hall to get Indigenous Peoples Day recognized in the city of Pullman, as well as on all 3 WSU campuses. Mm-hmm. And on the communication side, I would say just being in DTC, I had a lot of experience coming out of college in creating websites, podcasts, videos, photography. So like a variety of things that kind of just like helped me navigate my way through this.
Thank you. And I'll put another plug for the Native Student Center is that it is really open to all, and we do welcome you. We have First Friday feeds, we have events, and it's really important. The relationship building in this community in the WSU and Broad is very, very important. So please look that up. If you go native.wsu.edu, you'll see a list of our events, and you're all welcome and invited. Kyra, as an alumnus of WSU, will you share what brought you to NICWA and what excites you about working for a national Native organization?
Yeah, so I've always been passionate about working with Native people, Native youth, uplifting voices, because I feel like it's always kind of been harder being such a small percentage of the US. So I always wanted to make sure that that door was open for others. And I wanted to focus on helping Native youth, especially because I feel like I was giving so many opportunities when I was younger. And I think thankfully I came across NICWA, amazing organization with amazing leaders, as you can see. And I'm super grateful to be there. And I think even working with Native people, focusing on tackling issues that are important to our communities is something that I value so much. And we also have like talking circles. We have prayers before our meetings, and we are very open in all ways. So if people want to say a poem, if people, people close their eyes, bow their heads, if they pray, if they don't, it's just, we're open to a variety of different ways. So I think I'm just really grateful to work with the people that I do.
And thinking about your transition from WSU to into your career, do you have any advice for the students here in the room?
So I think something that has helped me is being in college. Like there's a lot of opportunities for students. So I would just say like go out there and take any opportunity you can. If somebody offers you something, do it. Make sure you network with a lot of people, because that's how I got a lot of opportunities that I did, was just like telling people about the things that I wanted to do, and how can I offer my help or support in any way, even if it was just like my time. People really appreciate that. So make sure you just get out there and do it.
Wow. Aren't these two amazing women? Let's give them a round of applause. And I'm not sure we all really understand the wealth of knowledge that we just received in a very short amount of time, like in very key, relevant, critical points that would have taken you an entire book to read and hours and hours. So thank you so much, Katsiyaoyao. I do want to just say, do you have any closing words? And then Dave, do you have any last?
30 seconds.
Okay, we'll give you 30 seconds at the end. Dave is amazing. Can we give him a round of applause for organizing this event and just inviting us into this space? I really appreciate it. So any closing words?
I was just going to say Lim Lems for having us here, and go Cougs.
Yeah. Sarah?
Oh, what do I want to say? I guess I would just say it's been some time since I was sitting where you're sitting, but I was a first generation college student, and I feel like I had so many opportunities in Western higher education, and I feel like I got really important training in my family and my community that also inform how I do my work and how I lead. And so, I often tell the story that I didn't know any social workers growing up. I didn't know that was a job. I didn't know anybody who did anything like that. But my dad, my Alutiiq dad, always told me, when we need help, we help other people. And when we do that, in the act of doing that, we always find the help that we need. And so I really feel like the reason that I ended up in social work was because of that teaching that my dad shared with me. So I would just encourage all of you at this really exciting time in your life to take advantage of the opportunities here in higher education, and to remember all of the important things about who you are and what you're called to do that you were taught by your family and community.
Oh, well, Katsiyaoyao, thank you both so much.
Thanks very much. I feel weird saying anything after that because that was so amazing, but I know people are interested in getting their hours in GivePulse. So for those of you who are looking to submit an impact in GivePulse and have these hours counted for service requirements you may have, all we need you to do is take a selfie or have someone take your picture and submit that with your impact. If you don't have a camera, I have one and would be happy to take your picture. Thanks everyone for coming today, and thank you for this wonderful panel.